This program is brought to you by Emory University.
It's my pleasure this afternoon to introduce our keynote speaker, Professor Peter Markowitz. But before I say a few things about Professor Markowitz's many accomplishments, I want to say a few very brief words about the dear friend of our center and mentor to many of our faculty for whom today's lecture is named, Don Browning. Don S. Browning was the Alexander Campbell Professor Emeritus of Religious Ethics and Social Sciences at the Divinity School of the University of Chicago, and the first Robert W.F. Woodruff Visiting Professor of Interdisciplinary Studies at our Center for the Study of Law and Religion here at Emory University. Professor Browning was a founding figure in practical theology and a catalyst in a wide-ranging discussion about religion, marriage, and family. The author of over 20 volumes, Browning spent a decade working with our center, running projects and authoring books that expanded our understanding of the family and its vital role in our society. Browning was a great, generous, and expansive mind who is missed in many places, including here at Emory. The legacy of his work on the importance of family lives on in this lecture series and in today's lecture. Peter Markowitz is Clinical Associate Professor of Law and Director of the Catherine O. Greenberg Immigration Justice Clinic at the Benjamin N. Cardozo School of Law. Professor Markowitz graduated magna cum laude from New York University School of Law, and following law school, he clerked for Judge Frederick Block of the Eastern District of New York. Professor Markowitz is speaking with us today on innovative responses to the immigrant representation crisis, an issue that has been present with us throughout the day from Judge Mark's opening plenary throughout all of the panels. The lack of an opportunity for immigrants to get counsel in immigration proceedings begets many of the situations that haunt us in today's proceedings. And we are incredibly fortunate to have Professor Markowitz here to discuss this issue with us because of his extensive experience in this area. I would be tempted to call him the Johnny Immigrant Representation Project, but it doesn't roll off the tongue quite like Johnny Appleseed does. From 2002 to 2005, Professor Markowitz was a Soros Justice Fellow and staff attorney at the Bronx Defenders, where he developed the nation's first in-house full-service immigration project housed in a public defender's office. From 2005 to 2007, he was acting assistant professor at New York University School of Law, where he also served as supervising attorney for the Immigrants' Rights Clinic. After his time at NYU, he founded and directed the Immigrant Defense Clinic at the Hofstra School of Law. Professor Markowitz joined the Cardozo faculty in 2008 and founded the school's Catherine O. Greenberg Immigration Justice Clinic. Founding immigration clinics is just Professor Markowitz's day job, however. He also served as chair of the New York Immigrant Representation Study, a project of the study group on immigrant representation launched by Judge Robert Katzman of the Second Circuit. The New York Immigrant Representation Study conducted extensive research on the state of representation for immigrants in New York City and published 2 reports, Accessing Justice, the Availability and Adequacy of Counsel in Immigration Proceedings, and Accessing Justice 2, a model for providing counsel to New York immigrants in removal proceedings. This work led to the founding of the New York Family Unity Project, the nation's first government-funded system of universal representation for immigrants facing deportation. As City Council Speaker Christine Quinn said at the launch of the project, without proper legal counsel, too many of our city's residents are being torn apart from their families. This pilot program will not only ensure fairness for New York's immigrant families, but will also work as a model for the rest of the country to follow. And it has. The Study Group on Immigrant Representation, the New York Immigrant Representation Study, and the New York Family Unity Project have inspired other cities and states across the nation to think creatively and innovatively about how to address the crisis of immigrant representation. It is my honor and pleasure to invite Professor Markowitz to the stage in the spirit of Don Browning to inspire us, potentially, to such change. Professor Markowitz.
Thanks so much for having me here today, and thank you, Silas, in particular, for inviting me. Okay, so to inspire, that's the job. So about a year ago, I met a woman named Sonia. She was wearing an orange jumpsuit. She was in the Bergen County Jail. The Bergen County Jail is a jail in New Jersey that houses immigrant detainees. They rent space. And she was about 25 years old, about 5 feet tall. When she stood to shake my hand, I was impressed that she seemed taller. She had a kind of dignity about her, a kind of grit that stood out. And it stood out because she had been in detention for about 2 years at the time I met her. And I'd met lots of other immigrants over the years who've spent months and years in immigration detention, and I've seen the way it could break people's will. But for Sonia, she seemed determined. She had come to the United States when she was 13 years old from Haiti. She immigrated legally here with her parents, and she landed in deportation proceedings for much the same reason that 27,000 other people did last year. She had been convicted of a crime. So on its face, kind of exactly the type of undesirable immigrant least deserving of our protection. But like so many others of that 27,000, there was much more to Sonia's story. She had been living in Brooklyn and had fled her home with her 2 young children when their father had become abusive. She was in the shelter system, and she was, by her own account, struggling when she got arrested for shoplifting. She had shoplifted a fancy outfit for her 2-year-old daughter. It was this arrest that landed Sonia in immigration detention. Her 2 children were taken away. They were put in foster care. She was put in the jail in New Jersey without an ability to see her children or her parents. They didn't have a car to make it out to New Jersey. And she appeared that first day in immigration court in shackles, literally, hand shackles, waist shackles, facing the possibility that she would be returned to Haiti, a country she hadn't set foot in since her preteen years. She had no family there. And in Haiti, immigrants are routinely detained for indefinite periods after deportation. But most importantly, she faced the very real possibility that she would never see her children again. When she was arrested for shoplifting, she was, of course, afforded an attorney the moment she set foot in the criminal court. Right? That's what our Sixth Amendment guarantees. But now that she was facing a potential lifetime of exile, where she could end up having to litigate in one of the most complex arenas of law, the intersection of criminal and immigration law, against trained government attorneys with the gravest of penalties hanging over her head, she had to go it alone. When she got to court, she was hoping that she would be let out on bond, but she was quickly informed by the immigration judge that she was subject to something called mandatory detention, meaning that the judge thought that he didn't have the power to let her out. Even if she was no flight risk, even if she was no danger to the community, if she wanted to fight her deportation, she was going to have to stay in custody for the months or years it would take to resolve her case. Many immigrants in Sonia's situation give up. They concede deportation to get out. And for many immigrants, it's a very logical choice. The odds of winning a removal case, detained and unrepresented, are close to 0. In fact, they're 3%. But as I mentioned before, Sonia had grit. She had a kind of like Captain Kirk, never tell me the odds type attitude. And she represented herself, and she won. So why then, 2 years later, was she still sitting in immigration detention when I met her? It turns out ICE disagreed with the immigration judge's decision and had appealed. And so while the case wound its way through the appellate process, she remained detained and she remained separated from her children. Sounds bad, but it gets worse. So it took about 30 minutes of interviewing Sonia to realize they got it wrong that first day in immigration court. She wasn't subject to mandatory detention. She should have been let out that first day, her kids never taken away, never put in foster care. But ICE had argued that she was subject to mandatory detention, and there was nobody there to make the legal argument on the other side. And so the judge, without the benefit of counseled argument, made a mistake. And she was separated from her 2-year-old son and her 5-year-old daughter. My clinic took Sonia's case, and we had her out in a couple of weeks. She was reunited with her children shortly thereafter. They were now ages 4 and 7, I guess. Those children are never going to get those 2 years back with their mother. Sonia is the face of the immigrant representation crisis in the United States. This is what it looks like to have a system where people are locked up, facing trained government attorneys with the gravest of penalties hanging over their head and no right to counsel. So I thought we'd spend some time today talking about the immigrant representation crisis. I want to talk first kind of about its scale, its nature, and its causes. And be forewarned, this part is a little depressing. Second, I want to talk to you about some of the truly transformative innovations that have arisen in the last couple of years around immigrant access to counsel. And then finally, I want to share with you some thoughts about the work left to be done, where we're headed now, and how we're going to get there. Okay, so first, how big is the problem? Last year, ICE, that's the prosecuting agency, the police and the prosecutors and the jailers in immigration proceedings, they placed over 270,000 people in deportation proceedings last year. And recall this morning, Judge Marks told us that there's over 400,000 cases pending. 270 of those were new last year. Over 40% of those people, around 100,000, had no lawyers and have no lawyers. Now, not all of them were locked up like Sonia. Some of them were on the non-detained docket. But for those that were, the statistics are much worse. EOIR, the immigration courts, doesn't publish representation data broken down by detention status, but the most recently available national statistics tell us that about 85% of detainees lack access to counsel. So that means there were 85,000 new Sonias last year. Sounds like a big problem, gets bigger still. One of the many dirty little secrets of immigration enforcement is that the vast majority of deportations, 77% last year to be precise, occur not as the result of proceedings before immigration judges. They expedited removal, voluntary returns, all sorts of other things where you never get to see a judge. Hundreds of thousands of people deported last year without ever getting to see a judge, let alone an attorney, and virtually none of them had counsel. The problem is vast, and that is the bad news. But there's good news. Before we get there, I just want to take a moment to talk about why we are where we are. What are the causes of the immigrant representation crisis? It's a complex problem with many causes, but I want to hone in on 3 that I think are the primary drivers. First, about 100 years ago, the Supreme Court decided a case called Fong Yu Ting, and in that case, they declared that immigration proceedings are civil, not criminal in nature. The case involved 3 Chinese nationals who were fighting their deportation under a law that required them to present, and I'm quoting, one credible white witness. In upholding those deportations and declaring their civil nature, the court concluded that none of the protections afforded to criminal defendants by our Constitution apply in immigration proceedings. Not the ex post facto clause, so Congress can, and often does, change the rules retroactively. Not the right to trial by jury or trial at all, and so we never get a jury in immigration court, and as I just said, often don't even get a judge. Not the right to protection against cruel and unusual punishment, so immigration judges are often unable to even consider the disproportionate gravity of the punishment in these cases, not relevant, not within their jurisdiction. Not the Sixth Amendment right to have one's case heard where the relevant events occurred, so an immigrant can be plucked off the streets of Atlanta and shuttled away to a detention center in a remote part of Texas or Louisiana where they don't have access to witnesses or counsel or family and face deportation there. Not the exclusionary rule attendant to the Fourth Amendment, so unconstitutionally obtained evidence can and frequently is used in immigration court. And most notably for our purposes, not the Sixth Amendment right to counsel. And so immigrants have not been deemed to enjoy the benefit of the Supreme Court's landmark decision in Gideon v. Wainwright requiring the appointment of counsel for indigent defendants in criminal proceedings. Notably, the court came to this conclusion over vigorous dissent because it held that immigration proceedings and the immigration powers were not derived from the Constitution at all. They were powers inherent in the nature of sovereignty, and being extra-constitutional in source, were not subject to the limits of the Constitution. Hopefully that sounds wrong to people in this room, and it is. And in the middle of the 20th century, the Supreme Court explained why that was wrong. They repudiated the inherent powers theory, and they held, and I'll quote, that the U.S. is entirely a creature of the Constitution. Its powers and authorities have no other source. It can only act in accordance with all the limitations imposed by the Constitution. So the Supreme Court repudiated the reason underlying the civil label, and no other articulation of a reason has ever been presented by the Supreme Court, but the ultimate holding of Fong Yuting remains good law. They're still civil, though there's no clear reason why. The civil label has been the first cause of the immigrant representation crisis, the reason why we don't have a constitutional right to appointed counsel. And the second cause underlying the immigrant representation crisis is the really unprecedented explosion of enforcement that we've experienced in the last decade. It is hard to overstate how unprecedented and anomalous in our nation's history the current mass deportation policies are. Consider this number. In the last decade, we have deported more people than in the century prior, and not by a little. In the last decade, we deported 3.8 million people. In the entire 20th century, we deported 2.4 million people. And in case what you're thinking is that this is must be driven by increased illegal immigration, that's not the case. There are fewer illegal border crossing events now than there were at any time since the early 1970s. So that's the second cause, the explosion in deportations. The third cause is a related explosion in the use of immigration detention. It's simply and intuitively more difficult for immigrants to get lawyers when they're locked up. It's more expensive, they don't have income, their cases are harder, etc. And consider these numbers. For the last several years, the Department of Homeland Security has locked up about 400,000 people per year. Compare that in historical terms to Japanese internment, where we locked up 120,000 people. We now spend more than $2.8 billion per year on detention and deportation. And the explosion in detention is driven by two factors. The 1996 immigration laws, which did a whole lot of bad things, created a mandatory detention statute. And so 2/3 of the people who are in immigration detention today are there because Congress has said the immigration judges don't have the power to consider whether they're a flight risk or a danger to the community. Then in 2006, Congress did something they've never done in any other law enforcement setting. They wrote into statute an enforcement quota. The law states that on any given day there must be 34,000 immigration detention beds, and until recently the Department of Homeland Security interpreted that to mean on any given day we must have 34,000 immigrants locked up. Can you imagine that rule if applied to the Atlanta PD? They have to have 34,000 or 10,000 or pick a number locked up on any given day, and the perverse incentives that would create for officers on the beat? That's the immigration system. So collectively, those are what are driving the immigrant representation crisis: explosion in deportations, explosion in detention, and the civil label that deprives us of a constitutional right to counsel. And that's the depressing part. But things have to get worse sometimes before they get better. And in the last few years, I think we've reached a tipping point, and the pendulum is swinging towards justice, I think. We're still just beginning, but I think in years to come, when we look back, we'll see this as our pre-Gideon moment. I think things are starting to change. And in fact, I can tell you the date when I think things started to change. It was February 28th, 2007. On that day, Judge Robert Katzman, now Chief Judge of the Second Circuit Court of Appeals, gave a lecture at NYU Law School called the Martin Lecture, which was something of a call to arms to the legal community. Second Circuit is functionally the court of last resort for immigrants facing deportation, as are circuit courts around the country. And at the time of the lecture, the immigration cases on the Second Circuit had swelled to occupy about 40% of the court's docket. And over again, Judge Katzman was seeing cases where individuals were being deported who shouldn't be. They had a legal right to remain in the United States. But because of either inadequate counsel or the complete absence of counsel below, the issues weren't properly preserved for review, and he was powerless to correct them. Turns out, federal judges don't take kindly to feeling powerless, and Judge Katzman was determined that if he couldn't fix it from the bench, he was going to find another way, and the lecture was just the beginning. After that, he convened something called the Study Group on Immigrant Representation, which was just mentioned. A study group is a group of about 50 lawyers, 50 to 70 lawyers, We meet in the wee hours of the morning, about 7:45 a.m. in the basement of the Second Circuit. We have people from every sector of the legal community, big white shoe law firm, lawyers, small practitioners, solo practitioners, government lawyers, immigration judges, federal judges, law professors, public interest lawyers, runs the gamut. And in those early years, it took some substantial hubris for this group with no money and no staff to think that they would make even a dent in this vast immigrant representation crisis. But we were united by a profound sense of an ethical duty to do what we could, and we were led by a visionary leader with unparalleled credibility, and it turns out those two are a powerful combination. In the years since those initial meetings in the basement of the Second Circuit, the group has been responsible for some truly transformative innovations in the field of immigrant access to justice, and I want to highlight just a few in particular. In 2011, the study that was previously mentioned, we launched the New York Immigrant Representation Study. It was a 2-year study that I chaired, and we knew a couple things going in. We knew that many people lacked counsel. We knew that many people had inadequate or incompetent, unscrupulous counsel. And we knew we needed an influx of resources to solve the problem. But we also knew that without the numbers, without the data, we would never unlock those resources. Judge Katzman's fond of saying, everybody's entitled to their own opinion, but not their own facts. And once you have the facts, they'll speak for themselves, and people won't be able to deny the scale of the problem. So the study looked at 3 things. We had kind of unprecedented access to EOIR, to the immigration court data. We had 5 years of data on every New Yorker put in deportation proceedings from 2005 to 2010. We were able to survey every immigration judge in New York about the quality of the attorneys before them, and we were able to survey all the nonprofits about their capacities and what they can do now, what they might be able to do in the future. And the findings were somewhat startling. First, it was clear that there were 2 factors above all others that were best predictors of outcomes in immigration cases. 1, whether you're locked up or not, and 2, whether you have an attorney or not. As I mentioned previously, if you were locked up and you didn't have an attorney, unrepresented, you had virtually no chance, 3% of winning. Compare that to if you were out of custody with an attorney, 74% chance of winning. Not a small difference. We also saw that the epicenter of the immigrant representation crisis was detained cases. These were the folks who were facing the most pressing and severe deprivations of liberty, the folks least able to defend themselves. And in one of the most robust legal communities in the world, 60 to 80% of them had no lawyers. And counsel made a huge difference. When you added counsel to a detained immigrant, it increased their chances of success by about 500%, 5-fold. So what that meant is a lot of people were getting deported who shouldn't be. They had a legal right to remain here, but they just couldn't identify that right on their own or vindicate that right on their own. Finally, it seemed that the immigrant representation crisis was as much about quality as it was about quantity. This number really surprised me. The immigration judges rated about 50% of the attorneys that appeared before them as either inadequate or grossly inadequate. So, armed with that, we convened the 2nd year of the study. We got together everybody we could think of who was kind of the most credible, most knowledgeable folks in the field. It included the chief judge with jurisdiction over New York and a whole lot of other people. And we asked them to do this. We said, look at the data, look at the information that we've gathered, and your charge is to come up with the most ambitious but still realistic, near to medium-term thing we can do to address the immigrant representation crisis. The result of that, and I believe that is in your materials, that year 2 report, the result of that is the blueprint for what became the New York Immigrant Family Unity Project. Following the release of that report, I was approached by leaders from the immigrant advocacy community in New York, and they asked me, would I work with them to make the recommendations in the report a reality? 6 months later, we had unlocked $500,000 from the city council to fund a pilot. The pilot became the first universal representation program for immigrants in the nation. It only served 190 people, but what I mean by universal is that the program didn't screen. It functioned like a public defender system. So we randomly selected certain initial master calendars, akin to arraignments, the first time people come to court. And the NIFUP attorneys went there and they took every single income qualifying case for people who didn't already have attorneys. Didn't matter if it was a good case or a bad case, if the person was a green card holder or illegally entered the United States or an asylee, it didn't matter whether they had a criminal conviction or not, everybody got a lawyer. The pilot succeeded well beyond our expectations. The data is not complete. These cases take a while to mature, and we did intake from November of 2013 through May of 2014. So about 2/3 of the cases are done now. A third are still working their way through the system. But we do have some substantial data now that tells us what happens when you add counsel for detained immigrants. The data tells us first that attorneys are critical to getting people out of custody. About 40% of the NIFUP pilot clients have been released, and recall that detention is one of the 2 best predictors of outcomes. The data also tells us that approximately 20% of the cases, the attorneys were required to initiate some kind of ancillary proceeding in a different forum in order to win the deportation case. For example, if you want to get special immigrant juvenile status, defense to deportation available to immigrants who are young and have been abused, abandoned, or neglected, you have to first go to a family court and get a special finding. We know that detained unrepresented immigrants can't do that. And so we know that those 20% of people would have been deported but for the NIFUP program. Most importantly, we now have sufficient data to project what our ultimate outcome numbers will look like. And this is really the bottom line. What impact did NIFUP have on clients' chances of remaining here in the United States? And I want to be careful here because the data is still incomplete. So these are projections, but if current trends hold, we're going to be able to show that NIFUP increased people's chances of success by 1,000%, tenfold. Now recall the study showed a 500% increase, but also recall that the study showed that half of attorneys were incompetent. And so here in NIFUP, we have some of the best removal defense providers in the nation doing this work, and it turns out that quality matters a whole lot. So armed with this data, we went back to the City Council last year, and we were able to convince them to bring the program to scale. The council allocated $4.9 million to ensure that every single person detained in the New York City Immigration Court and every New Yorker detained in any nearby court would be afforded attorney. For the first time in history, in any jurisdiction, anywhere in the United States, we have a functioning public defender system for immigrants. New York City can now say that no New York family will lose a loved one to detention and deportation simply because they can't afford counsel. That just doesn't happen in New York anymore. Never again another Sonia, and that's an amazing thing to be able to say. This year, approximately 1,400 people in New York are going to get those NIFUP attorneys. And obviously, that's all the most important impact of the program. But as someone who has litigated in that detained immigration court for my entire career, there's another change that has really struck me, and it's a change in the culture of that court. It's truly amazing what happens when you add an institutional defender into a system where there was no defense counsel previous. Immigration judges, and I hope Judge Marks will back me up once we're on the panel, have been ecstatic about the program. They no longer have to spend the significant amount of time it takes them to evaluate potential defenses for pro se immigrants, and that's their responsibility in pro se cases. And moreover, the quality of the adjudications are just better. That's the way an adversarial system's supposed to work. You get the best arguments from both sides, and judges get to judge. If Sonia had an attorney, the mistake would never have been made on that first day. More surprisingly to some, though, ICE has really embraced the program. They've bent over backwards to work with us to make this program work well and efficiently. It turns out that when everybody has competent counsel, the system just works better, and that's really better for everybody involved. Cases move faster, ICE prosecutors get to know defense attorneys, and they work out issues that previously took a long time to litigate. And perhaps most helpful to ICE is that in those cases where immigrants truly don't have a defense to deportation, it's in no one's interest to prolong them, least of all the immigrants, right? When detained immigrants are destined to lose and be deported, if they're represented and properly advised, they're going to concede their deportation at the earliest possible moment. The best we can do for these individuals is to minimize their time in detention before they're deported. And indeed, in 83% of the cases with negative outcomes in the NIFUP pilot, the immigrants conceded their deportation on either the first or the second appearance in court. So in short, NIFUP has really catalyzed a sea change, not only for immigrants, but also in the culture of the immigration courts. The kind of abysmal dysfunction that was the immigration courts purporting to use an adversarial system, but with one adversary missing, has now been replaced by the more mundane dysfunction that we see in our criminal courts all around the country. So that's NIFUP. The Immigrant Justice Corps is a wholly separate, equally impressive, and often confused initiative that was also catalyzed by the Katzman Study Group. This one is truly the brainchild of Judge Katzman. I worked with him to develop the project, and I served as one of the founding executive directors, but it's very much Judge Katzman's baby. The Justice Corps is a prestigious new fellowship program for recent law and college grads interested in becoming immigrant advocates. There are currently the first class of fellows, 35 of them, working in immigration nonprofits in New York, doing not only removal defense, but the full panoply of immigration legal services. Once at scale, that number is going to be closer to 100 fellows. And beyond the significant infusion in legal capacity that the fellows bring, they also help solve that quality problem that we were talking about before. We're going to create a renewable source of exceptional, highly ethical, highly trained attorneys to repopulate that sector of the immigration bar. And to be clear, while there's a serious problem of quality and unscrupulous attorneys, there are also exceptional attorneys in the immigration field, and I don't mean to impugn those by association. And the third thing that the IJC, the Immigrant Justice Corps, is doing is that in addition, part of their mission is to kind of innovate new modes of service deliveries and new technologies to make immigration legal services better and more cost effective. And if we're gonna meet the kind of vast need that is the immigrant representation crisis, that's gonna be a real key part of the problem. So lots of exciting innovation going on in New York, about $7 million more being spent in New York on immigrant representation this year than last year. But how do we export that energy and innovation to the rest of the country? When I talk to folks about what's going on in New York, I often get the response, yeah, but that's New York, that can't happen in fill-in-the-blank jurisdiction. Well, believe me when I tell you that when we first started talking about creating a public defender system in New York that would cost $4 to $5 million per year, people did not see that as a realistic thing. Laughed at, we were told we were kidding ourselves, got dismissed by more people than I can count. But we were persistent, we were relentless, and eventually we brought around the folks that needed to be brought around to unlock the dollars. And it can happen in other jurisdictions as well, and in fact, it's already started. There are 5 jurisdictions right now that I know of that are working on replication efforts to get their own NIFUPs up and running. The Immigrant Justice Corps, I know the IJC board has national ambitions, and that program could well grow to a national program in years to come. Moreover, other jurisdictions have already followed New York's lead and invested in immigrant representation in lots of different contexts. The U.S. Department of Justice and the state of California, among several others, provided money over the summer to help pay for lawyers for the child migrants that we talked about earlier. A new NIFUP pilot was just launched in Buffalo. And public defenders across the country have started to add immigration staff attorneys to their office to provide first immigration advisals on criminal case, but in some cases also to provide immigration legal services. Cities and states previously saw immigrant representation as not their problem, it's a federal issue, but as we've been able to demonstrate to them how the harms precipitated by the immigrant representation crisis are visited upon cities and states, they're coming around. Indeed, just this past September, I think your very own Fulton County passed a resolution urging the Fulton County Sheriff to stop handing over individuals for deportation to ICE. So it seems that there's even will here in Fulton County. So things are starting to move across the country. And things are also moving in our courts. In a really landmark decision, a district court in California found that mentally ill detained individuals had a right to appointed government counsel if they couldn't afford it. And the government acquiesced in that case and is right now setting up a program to ensure nationwide that detained mentally ill or mentally impaired individuals get appointed counsel. People are building on that precedent already. There's a nationwide class action pending in Seattle in district court that's seeking to win the appointment of counsel right for children in removal proceedings. And while I don't think the Supreme Court is on the cusp of an immigration Gideon just yet, there are some hints in the recent case law that the Supreme Court is moving in the right direction. First, in 2008, it issued a decision called Padilla v. Kentucky, and in that decision, the holding was critically important that criminal defendants had the right to advisals about the immigration consequences of contemplated dispositions, and so that drove a lot of the investment in the public defender offices that I was talking about previously. But perhaps more importantly in the long term, in Padilla, for the first time in 100 years, the Supreme Court revisited the issue in Fang Yu Ting, the civil nature of removal proceedings. And it said in a lengthy discussion that ultimately is all dicta, but a lengthy discussion, it talked about how immigration proceedings had changed over the last 100 years and how now it really is uniquely difficult to classify them as either civil or criminal. So we see movement. Then in 2011, in a case called Turner v. Rogers, this was not an immigration case, but it was a case where the court was called upon to decide whether the due process clause required the appointment of counsel. And unlike the criminal protections, the due process clause does apply in immigration court. And in that decision, the court intimated strongly that if someone's personal liberty was at stake and they were litigating against a government attorney, that in that situation, the court suggested maybe the due process clause does require the appointment of counsel. And that sounds a whole lot like detained removal proceedings to me. So we've come a long way. More progress has been made on immigrant access to justice in the last few years than ever before. But we're not there yet, and so how do we get over the finish line? How do we turn the tide and get to our immigration Gideon moment? It seems to me that we get there by addressing those three factors that we talked about before: the lack of legal right to counsel, the anomalous mass deportations, and the huge spike in detention. And notably, we're making progress already, albeit modest. We've already talked about the progress in the courts. Representation rates, while still abysmally low in my view, have gone up a lot. In fiscal year 2009, 35% of immigrants nationwide had attorneys. In this past year, that number was 60%. That's a big change in a relatively short period. In regard to the scale of the deportation machine, while our numbers are still extremely high in historical terms, they're headed in the right direction. The recent trends demonstrate some significant progress and reason to be hopeful about more to come. One study recently showed that there'll be fewer deportations initiated in 2014 than at any time in the last decade. It also showed that immigrants are faring better in their removal proceedings, with approximately 50% of immigrants prevailing in their deportation proceedings last year as compared to 20% a decade ago, also a big change. Moreover, in regard to detention, data which just became available this week shows us that detainers are the primary mechanism by which immigrants land in detention. The issuance of detainers dropped nationally 39% between fiscal year 2012 and March of 2014. And guess what state showed the most dramatic decline? Georgia. Georgia, 58% decline in detainers last year, or during that period. And as you surely heard, if the president is to be believed this time around, we're about to hear some dramatic changes in enforcement priorities nationally that could protect millions from deportation. But for all the innovation and progress that we've made in expanding access to justice, sadly, injustice still remains the rule, not the exception. And to change that, it seems to me that we need to change our national conversation on immigration. For too long, the conversation has been distorted by the inaccurate and inflammatory themes of criminality, lax border enforcement, and national security. In reality, the overwhelming majority of immigrants in deportation proceedings have never been convicted of any crime. And in reality, border enforcement has never been more robust in our nation's history, and illegal border crossings are at a decade's lows. In reality, our vast immigration enforcement system, the billions of dollars we spent, have not resulted in any, not one notable national security victory. Immigration is the great civil rights issue of our day. It is to the 21st century what the civil rights movement was to the 20th. It's been said that the arc of history bends towards justice, but others have observed that it doesn't bend by itself. It's our job to bend it. And we do that through action. Some concrete and individual, like the hundreds of lawyers who stepped up individually to volunteer to represent the wave of kind of child migrants over the summer. Some collectively, like the 50 lawyers who hang out in the basement of the Second Circuit. And it's all of our responsibility to act. I promise you this, that when we look back at this period in years to come, when we talk to our children and our grandchildren about it, we're going to want to be on the right side of history. We're going to want to have said we acted. And much of what we need to do is incremental and interpersonal. The way we get there on the immigrant representation crisis is the same way we get there on comprehensive immigration reform. We need to change the national conversation by exposing the distortions that have allowed those inaccurate themes to warp our discourse, and we need to reorient our national conversation towards more accurate and productive themes like family and economic vitality and national identity. And we do that by telling stories, true stories, about the way our current immigration policies are affecting human beings, people like Sonia and the thousands like her who didn't deserve the treatment they received from our government. Thank you.
The preceding program is copyrighted by Emory University.